Hello, everybody, and welcome back to Coffee with Craig. We very much appreciate you guys tuning in and joining us as we talk firearms policy, you name it. We're talking about it here on Coffee with Craig, sponsored by Sacramento Black Rifle and Sparks Black Rifle. Want to remind you guys, please remember to like and share this video feed. Trust me, your friends are going to want to hear this conversation. How do I know? Because you and your friends keep asking me questions about our topic today. So please make sure like and share the video so that your friends can join in the conversation. Also, subscribe to our YouTube channel. Follow us on Facebook so that you can get the alerts whenever we go live. Finally, want to remind you, fpcgear.com. That's fpcgear.com. It is the place to go in order to purchase very cool t-shirts. In order to support the Second Amendment. All right? So if you want to support the Second Amendment and you want to look good doing it and know that every dollar that you spend is going to go right back into the fight for our constitutional right to keep and bear arms, fpcgear.com is the place to go. Go be there or be square. So, you guys all know the Ninth Circuit Court of Appeals, a three-judge panel, in a 2-1 decision, ruled in favor of open carry in the state of Hawaii. And I know you know this because you guys have been asking me a bunch of questions about it. Now, as I always say, whenever I get asked questions, I always say a couple of important things. Number one, I am not a lawyer. Number two, most importantly, I am not your lawyer. So, seeing as how I can't provide your lawyer, I figure that I would be able to bring on board for the show today a lawyer, one who is very, very knowledgeable about these topics, in order to answer some of the questions that you've had for me, but also to kind of shed a broader perspective on this particular topic. So, with that, without any further ado, I would like to welcome Mr. Joshua Prince to the show. How are we doing today, sir?
Doing well, Craig, and yourself?
I am doing just dandy. Now, I realize that you're in the state of Pennsylvania, correct?
That's correct.
That is correct. So not exactly free America, but probably freer than the state of California.
Most definitely. We have a lot of protections here in Pennsylvania, and we have a great state protection in our Constitution, Article 1, Section 21.
Well,
but
excellent.
Unfortunately, not everyone's so privileged.
And not everyone has that privilege. So let's just jump right into it. First and foremost, why don't you just kind of give our listeners, our viewers, a little bit of first of all, the kind of the general perspective about the decision that was made by the Ninth Circuit.
So the decision just came down yesterday in Young versus Hawaii. That decision addressed the issue of whether an individual could open carry a firearm in the state of Hawaii, given the fact that Hawaii requires a license or permit in order for an individual to either conceal carry or open carry. The plaintiff in that case, Mr. Young, had applied on 2 occasions for permission to be able to either conceal or open carry, and he had been denied by the local county sheriff. And so there was an original case that was brought in the District of Hawaii where the court dismissed his action somewhat soon after his filing of it under a motion to dismiss, finding that there was no Second Amendment protection to conceal carry and also open carry, I should say. It relied on the Peruta case that the Ninth Circuit had previously decided about 2 years ago, where the Ninth Circuit en banc, meaning in front of the entire court, decided that the Second Amendment does not protect concealed carry of a firearm in public. That was after the first decision by the Ninth Circuit, which was only in front of a panel or a 3-judge group that decided that concealed carry was protected by the Second Amendment. So at the end of the day, going into this case, we had a decision from the Ninth Circuit that said, no, concealed carry is not protected by the Second Amendment. However, in that en banc Peruta decision, the Ninth Circuit specifically stated it was not addressing whether open carry would therefore be protected by the Second Amendment. This case somewhat picked up where Peruta left off, And the district court, as I alluded to earlier, found that even open carry was not protected by the Second Amendment. The appeal then went up to the Ninth Circuit. And as I mentioned earlier, yesterday we had a panel decision from the Ninth Circuit. Again, that's a group of 3 judges, not the entire court, that found that open carry was protected under the Second Amendment, especially based upon the fact that the court previously ruled that concealed carry was not protected by the Second Amendment. The decision goes to great lengths to look at the historical context of the Second Amendment, what was understood by our founding fathers, what the case law provided, and all reflective of the fact that while a state may be able to restrict concealed carry in public for purposes of self-defense, it can't absolutely prevent an individual from having a firearm in public for purposes of self-defense. Therefore, in this situation, they found that open carry had to be allowed because of the fact that concealed carry has already been ruled to not be protected by the Second Amendment. Now, one other point before your next question, and maybe you'll get to this, is the fact that this, as I mentioned before, was a 3-judge panel. 2 of the judges were George Bush appointees. 1 was a Reagan appointee. This was a 2-to-1 decision, meaning one of the Bush appointees did dissent and wrote a dissenting opinion, which would have upheld the prohibition on open carry. I think this sets this case up for likely petition for rehearing en banc, meaning again in front of the entire court. And I honestly don't know what the Ninth Circuit en banc would do in this case based on its prior decision in Peruta.
Okay, so and this, you're right. This actually does bring to mind my question. So ultimately, what it comes down to, and I think in Peruta, the question that the attorneys were asking was, do we in fact have a right to bear arms as is stated in the Second Amendment? And the question that was answered in Peruta was, do we have a right to conceal carry? And because they answered that question, what you're saying is, well then, all right, so we know there's no right to conceal carry, so there's only one way in which to exercise your right to bear arms, and that's open carry. And so as a part of that decision, and like I think you pointed out, the historical reference to open carry versus concealed carry, the court then ruled that, well, there must be a right to open carry. Now, what happens if, let's say it does go en banc. What happens if then en banc they say, well, no, there's also no right to open carry?
At that point, the option would be to petition for certiorari before the U.S. Supreme Court, which is basically the mechanism by which you ask the Supreme Court for permission for it to review the decision. I think depending on where we stand with the nomination of Justice Kavanaugh at that, or hopefully Justice Kavanaugh at that point, will kind of determine whether or not the court agrees to hear it. My own belief is that the court has been reluctant to grant certiorari in Second Amendment cases since really even a little bit prior to Scalia's death, because of the concern of having enough votes to, under the Second Amendment, find that this would be unconstitutional. And by that I mean it would be unconstitutional to restrict an individual's Second Amendment rights in these fashions. That's my own thoughts based on what I've seen. There has been some thought that it's been Justice Kennedy who would be the deciding vote and who was not really in favor of those cases. And it's for that reason that the court was denying certiorari, because they'd rather allow these lower inferior court decisions to exist than to agree to hear a case and have a devastating decision issued by the U.S. Supreme Court that affirms one of those lower court decisions. I know there's also some conjecture out there that it may be Chief Justice Roberts that has not been supportive of these Second Amendment cases. In my opinion, looking at some of the cases and decisions that have been rendered before, I think it's more likely that it's Justice Kennedy, but none of us know for sure. So I think assuming that Kavanaugh is affirmed by the Senate and now becomes a justice of the U.S. Supreme Court, we will see what happens with cases that are on petition for certiorari regarding the Second Amendment and whether they now start being granted. The other thing I do want to mention is a lot of people overlook the Supreme Court's decision in Caetano. That was the stun gun taser case. The determination finding that tasers and stun guns fall under the Second Amendment was a per curiam decision by the Supreme Court, meaning there was no general decision by the Supreme Court other than simply stating by the court we're reversing the finding that the Second Amendment doesn't protect tasers and stun guns. Justice Alito issued a concurring opinion, and I think that's what everyone really needs to focus on, because in his concurring opinion, he states that the court only begrudgingly affirms per curiam this decision. That was, to me, a shot across the bow, trying to tell Second Amendment advocates that there are not enough votes, generally speaking, on the Supreme Court to uphold the Second Amendment in many of the challenges that are being petitioned for certiorari before it.
Wow. Okay, so now let's talk just kind of in a practical sense. In a practical sense, for someone who desires to, in this case, open carry in the Ninth, well, anywhere in the United States, but specifically in the Ninth Circuit, what does this mean? Does this mean now that, like, for example, in California where open carry is illegal, does it mean that I can now open carry?
First and foremost, I'm only licensed in Pennsylvania and Maryland to give state law advice. Federal issues I can handle across the U.S., and I actively do. Obviously, because this involves state law issues in California, I'm always going to, well, assuming your viewers are from California or other states covered by the Ninth Circuit, I would suggest you reach out to competent counsel that's admitted in that state with any questions. However, my own advice would be non-legal advice, that at this point in time, it's way too soon to take any action. I truly believe, based on the fact that there was a dissent to the decision, that it is likely that the County of Hawaii will petition the Ninth Circuit for rehearing en banc. If that happens, obviously we don't know what the outcome will be. I believe, but don't quote me on it, that the Ninth Circuit's local rules provide that if a petition for rehearing is filed en banc and the court grants it, it automatically stays or otherwise vacates the prior decision of the court pending a final determination by the court en banc. So that's a long way of saying don't go out and do anything stupid. Wait until we know what is going to happen in this case, until we get what's called a final determination. Then I think attorneys who are licensed in the states where you may find yourself would be able to give you better guidance on what conduct is lawful or not. Also, I will say this is not the first case of this type. We've had Wren out of the District of Columbia, where it was ruled that an individual does have a legal right outside of their home to conceal carry a firearm. It struck down a number of the licensing provisions in the District of Columbia, which has allowed a lot of people now to be able to get licenses to carry in D.C. We also had the Moore decision that likewise, that was out of the Seventh Circuit, that found that an individual does have the legal right to carry a firearm outside of one's home in a concealed manner. I believe there's some state law decisions. I think Illinois had one recently where it also held, but under its state constitution, that an individual does have protections outside of the home. The concern I always have is, unfortunately, we have a number of courts that have held the opposite. Even here in the Third Circuit that covers Pennsylvania, although the court acknowledged that there must be some right to your Second Amendment rights outside of your home, it refused to invalidate New Jersey's draconian licensing provisions. So that's why I always say make sure you get competent counsel who can properly advise you, because the last thing you want is to end up being prosecuted because you violated the law and you don't have a legal argument, or at least one that's been addressed previously by the courts, that your conduct was lawful.
I think you just hit the nail right on the head. And I always tell people, look, when it comes to, And it's sad that especially when it comes to the right to keep and bear arms, it's important that you know what you're getting yourself into, that as you exercise that right, that you go into it with your eyes wide open. And it's such a highly technical area. It's important to know. And I always say this, in a safe, in the best environment, it's always good to know what your rights are before you take action or participate in something. And I think that's the exact same case here. It sounds like that's the sort of non-legal, just common sense advice that you're giving folks.
Absolutely. I don't want to see anyone prosecuted. And trust me, I know there's some people who say, I'm happy for it or ready for it. I want to fight this to the bitter end. Usually their opinion changes when they find out what all's involved in fighting it to the bitter end, and the fact that they may end up in jail regardless of whether we believe that they should and whether their conduct was constitutionally protected.
Well, on top of it, not just in jail, but having to pay legal fees and really in many cases having your personal finances and financial future devastated simply by trying to defend yourself. A lot of people don't realize.
That's right. And a lot of people don't recognize the fact that Heller and McDonald, the attorney's fees involved in both those cases were over $1 million. So, keep that in mind when we're addressing constitutional issues. It is not cheap, and that it takes a lot of time and effort, especially if your viewers read the decision in Young. When you look at the historical review that the court does, it'll become apparent at the amount of time, the voluminous amount of time that needs to be spent reviewing the historical context, law reviews, writings of the time, anything that would suggest either way whether in that time frame individuals believe this to be something protected by the Second Amendment or not. So always keep that in mind. Also, the other thing that's really important to keep in mind, and I mentioned this earlier, is both Heller and McDonald were 5-4 decisions. One justice voting the other way would have resulted in the complete opposite determination being issued by the court.
Wow. Well, hey, thank you so much for taking the time to come on and discuss this information. Do me a favor, just a quick opportunity to promote your work, your organization, and the stuff that you're doing, and let folks know how they can get a hold of you.
Sure. My name's Joshua Prince. I'm with Firearms Industry Consulting Group. It's a division of civilrightsdefensefirm.com. You can find us online at firearmsindustryconsultinggroup.com. You can also reach out. Our phone number is 888-202-9297. Again, that's 888-202-9297. Pretty much we handle all firearms law issues in the state of Pennsylvania and Maryland and any federal issues across the United States. We have a substantial amount of experience dealing with everything from Second Amendment as applied challenges to representing federal firearms licensees and overturning erroneous denials for individuals. So if you have a firearms law issue, we're here to help.
Fantastic. Once again, thank you so much for coming on and for being thank you for everything that you do. The facilitation of the right to keep and bear arms is not an easy one. It takes a lot of people. It takes FFLs. It takes firearms trainers. It takes attorneys who are willing to stand up and help us to be able to fight for our rights, and organizations that do that. So once again, thank you so much for all that you do and for joining us here today.
Thank you, Craig. I really appreciate it. It's been an honor being able to stand side by side with FPC and fight some of these issues together, such as the bump stock rulemaking that we had drafted that substantial comment for FPC in relation to. And I just want to thank FPC for everything it does to continually defend our inalienable right to keep and bear arms.
Well, we appreciate your efforts, and once again, it's always a pleasure working with you. All right, everybody, that's going to be it for today's Coffee with Craig. We thank you guys, and we appreciate you guys tuning in. Please remember, share this video so that folks can have a better understanding of what exactly this ruling meant. but also so that they can have a better understanding of who we are here at the Firearms Policy Coalition. As I always like to say, we are the home in the fight for civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.